So we are slightly behind time-wise, which is completely natural, I think, at events like this. I have been told that we will end on time, though, and so we have a hard stop of 4:50 to make room for the final closing remarks. Each of the panelists will present for about 20 minutes, and we'll go in the order of Brian, Amanda, and then Andrew, and we'll have time for short Q&A at the end of the session. If you're virtual, please put your question in the chat, which is being monitored. We'll preserve questions until the end and try to answer them there. If you're in person, obviously, we'll raise hands and do the microphone thing, and we'll try to trade off between virtual questions and in-person questions. A reminder that unless you're actively eating and drinking in the law school building, we have to wear masks, unfortunately. And so to introduce our panelists very briefly, just given the late start, I'll keep them relatively short. So our first speaker is Brian Pierson, who co-leads Godfrey and Kahn's Indian Nations Law Team. Brian is a proud 1983 graduate of this law school. He's been practicing in this area, representing Indian tribes for over 30 years. Our second presenter is a double badger. I think most of you have heard that term already today. She has earned 2 degrees from the University of Wisconsin-Madison, Amanda White Eagle, who advises and counsels the Hogen Nation government as senior tribal counsel. She's previously served in a number of other roles for the Ho-Chunk Nation, and she has served as a county court commissioner in Wisconsin. And then finally, we have Andrew Adams, who serves as a justice of the Muscogee Nation Supreme Court. He's Chief Justice of the Santee Sioux Nation of Nebraska and Justice of the Gun Lake Supreme Court. Andrew hails from Michigan, where he earned his BA and MA, but he too is a UW law grad, and so I'm absolutely thrilled to see 3 of our successful and esteemed alums here today. Now, let me caution you that I know nothing about Indian law, as you might have picked up from my bio, and so I'm going to be relatively passive, and so it really is up to you all to ask questions of our guests, because I am not competent to ask questions. Brian.
Thank you, Professor Yackee. Also like to thank the organizers, Dylan and Crystal. I really enjoyed the presentations this far. I'm glad to be on a panel with Amanda and Andrew, both of whom I've known for many years. And of course, it's always a pleasure to be presenting in Godfrey and Kahn Hall, which I regard as home turf. So we are the tribal powers portion of the program. Tribal powers don't exist in a vacuum. They exist in competition with federal powers and state powers. And we're going to examine in my short presentation how tribal powers can shift the equation away from what historically has been dominance in this area by the federal oversight power, as well as an undercurrent of state law authority. Okay.
If the clicker's not working,
yeah,
have you just kind of, there you go.
Oh, there we go.
Technology works.
I'm going to kind of quickly go through some of these. Obviously, I wanted to tie the presentation in with the restatement. This recites some of the basic principles of Tribal Power 15, basically talking about the plenary power of the federal government, the taxing power of tribes. Of course, that's always in competition with state taxing authority, the power to exclude, which very much lies at the one of the bases for the tribe's exercise of jurisdiction over rights of way, and tribes' power to enforce laws, which is often challenged by state governments. These are some other relevant portions of the restatement, which those of you who are familiar with Indian law will recognize this is basically a under A, that's a restatement of the Montana rule. What's relevant for our purposes, actually, I have a pointer here. Oh, wait. Oh, there it is. Oh, there it is. So B is the Montana rule, which is that tribes can't regulate non-Indians. U.S. Supreme Court hates that, even in Indian country. However, there are these two exceptions. And the first one is that tribes can regulate non-Indians who enter into consensual relationships with the tribe or its members. That's going to be important in the context of a right-of-way presentation, because although the federal government has largely dominated this area since the 48 Act, tribal consent has been a requirement. So there you have it, your consensual relationship. So why is this important? This is important because it goes to territorial sovereignty, and you have these tribal powers competing with state authority, particularly over non-members, including utilities, the entities that actually use right-of-ways. That's like the Montana test. That's White Mountain Apache versus Bracker, another 1980s era decision that governs when states are allowed to reach inside Indian country and regulate non-tribal members. It's one of the legal doctrines that's at play here. And then you have the federal plenary authority, which has been actively exercised. And what I'm going to focus on here, and I'm going to try to go quickly, is I'm going to run through what has historically been federal domination with a state undercurrent, and then talk about the 2016 right-of-way regulations, which are a very powerful mechanism whereby the Department of the Interior is trying to shift the authority over rights-of-way back. So when we talk about powers of tribal government, we talk about tribal sovereignty. We're talking about who has the authority to regulate in Indian country within regulation, within the reservation boundaries. And a lot of credit, I think, Kevin.
So I just want to make sure that we're sharing the screen.
Okay. So if we're not sharing the screen, let me know and I'll present. I'll try to make up for that. This regulation was enacted in 2015, became effective in 2016, and Kevin Washburn deserves a lot of credit for it and his team. He was the Assistant Secretary for Indian Affairs at the time, and unlike in the area of leasing, which is another important aspect of this, Congress did not legislate. So this was a very proactive attempt to shift the balance purely through regulation, even though the ultimate approval authority for rights of way remained in the federal government. Okay, we're going to talk a little bit about rights of way. I'm going to go through this quickly too, because most people understand what a right of way is, and this is a law school, so I don't really think I need to go into this. I guess the one thing I'll say is we'll kind of run through this. There's a distinction between rights of way that are purchases of fee simple interest and easements. We're going to be talking about easements. And this is the context. Utilities, gas and electric, water, sewer, telecom, also used to be railroads, telegraph lines, telephone, anything like that, rights of way. I'm going to talk a little bit about how it works outside Indian country. This is important because this has been the underlying assumptions under which the utilities operated and even the Department of the Interior operated in many ways. And these 2016 federal regulations significantly shift that framework. So outside Indian country, the utilities have a tremendous amount of flexibility on how they can obtain rights of way. And it's all under state law. They basically enter into agreements with the landowners, and if the landowners are not agreeable, they can condemn the right of way. So this is an incredibly powerful tool. And the underlying premise of this, of course, is that, hey, rights of way are in the public interest. And normally they serve a wide range of interests, and therefore these utilities should have this power. And so virtually all states give them this power. This is just an example in Wisconsin, and I think in other states it's the same way, that anybody who wants a right of way for these broad purposes has the power of condemnation, which is a governmental power that's basically being delegated to these private entities, or in some cases, heavily publicly regulated entities. You have this in your program, but we won't dwell on this. I mention it because this is what's in the minds of the electric companies, the gas companies, the telecom companies that are running their lines through reservations. So it's important for tribes to understand that these are their operating assumptions for how these rights of way work, including the notion of fair market value. So in Indian country, there's the federal plenary authority, and rights of way have been included from the very beginning. This is just an example of a treaty that's very well known in our state, the 1854 treaty that created the Chippewa reservations up north, included rights of way. You see rights of way in the Stevens treaties in the Northwest with the Northwest tribes. They're in a lot of treaties. The Fort Laramie Treaty of 68, that whole Red Cloud War was over opposition to a railway. Well, in the treaty, they say, okay, you can have your railway. So it's all part of the manifest destiny. The federal government's assumption was that there were going to be these lines through Indian country, and the treaties provided for those. And then you get the legislation on these things. You have the compensation is determined by the secretary. So the Secretary of the Interior, his delegate, back then it was called the Office of Indian Affairs. Now it would be the Bureau of Indian Affairs, and sort of make those determinations. If not subject to state taxation, there you get the deference to the states. Well, if the states are going to tax you, then we'll keep our hands off of it. And the condemnation of under state law, again, invoking state law, of allotted lands, individual allotted lands. So those of you who are familiar with that important distinction between land that's titled to the United States in trust for the tribe versus land that's titled to the United States in trust for individual tribal members, we call the latter category allotted lands. Here are another more examples of this, and the point of these slides is to show deference to state law, subject to condemnation for any public purpose under state law. And that's still effective today. And that's really important when it comes to right-of-way disputes, because ultimately a utility can condemn individual allotted lands. Another example, one slide too many. This is the current law that's in effect, and the federal regulations that were effective in 2016 are still based on this 1948 law. And let's see. So the rights of way are granted for all purposes as such conditions as he may prescribe. Again, we're talking about the Secretary of the Interior or the person to whom he or she nowadays has delegated that authority. And here you have the consent required by the federal government, required from tribal consent required under the 48 Act. Jeez. Sorry about that. Again, under the 48 Act, this is just the codified version. Compensation as determined by the secretary. The secretary, again, is driving the bus. So historically, what happened on these things is typically a utility would go not to the tribe, but to the Secretary of the Interior saying, we want to put a line through there for gas, or we want to put a line through there for oil, or for electric lines. And the whole thing would be drafted up by the local Bureau of Indian Affairs. And then they would send it over to the tribal council, where it would typically be rubber stamped. And sometimes it was a line that would serve the tribe, and sometimes it was a transmission line that was just going through the reservation. But until recently, most tribes typically just dutifully passed the resolution, and they would often provide no compensation for the tribe at all. And in many cases, they would be perpetual. And a lot of these things still exist, or there would be nominal compensation. And again, I mean, nobody was taking a kickback or anything. It's just the feeling of the federal officials is kind of like, well, that's the way it works. That's the way it works in the state. And the public interest is involved there. So why should we make these guys pay for these things? So, these are the current regulations, and I should have had some more bullet points here, because here I'm it makes explicit, and this is in these regulations are found at 25 Title 25, Part 169 of the Code of Federal Regulations, and there are also very emphatic, specific provisions at 169.9. 169.10, 169.11, that in all kinds of different ways sort of make the same point. The same point being that granting a right-of-way does not eliminate tribal jurisdiction. The grant of a right-of-way does not eliminate tribes' taxing authority. Granting a right-of-way does not remove the tribe's sovereignty. And then they also make emphatic that state and local taxes are not permitted of rights of way, and state and local regulation of the rights of way is not permitted. Now, those are provisions in federal regulations by a Department of the Interior in 2015 that was very mindful of the federal government policy of self-determination and tribal sovereignty. There's a ton of case law on that. And so some of these pronouncements in the regulations could be subject to litigation, because the Supreme Court has handed down cases on these things. But they're basically sound, and they're supported in the restatement, and they form the basis for what we regard in working with our clients as a more modern approach to rights of way that retains for the tribe its regulatory authority, and also creates a revenue stream. And we work with tribes who are very under-resourced tribes, for whom even a modest revenue stream is very important. So this is sort of paraphrasing an overview of I call them the 2015. They became effective in 2016. This talks about the payments. So instead of this fair market value that is based on state law concepts, the federal government is now going to approve any payment amount negotiated by the tribe. It used to be that the approval part of the equation was the dominant one, and then the tribal consent was the afterthought. So now what the Department of Interior is saying, the law hasn't changed. Under the 1948 law, we still have to approve these rights of way, but we're providing you with a regulatory framework that makes crystal clear that we're going to defer to you, and the approval is going to be the afterthought if you want to take this authority that we're emphatically reinforcing here. So the valuation, for example, so what might happen with that is you take, you have a line running through a reservation through 40 acres. Let's say it's unimproved forest land, and it's 33 feet wide, as a lot of these things are. Well, what the valuation used to be was if the 40 acres unimproved is worth $2,000, they would calculate the square footage of that thing, and they would, you'd end up with very little compensation indeed, because it's like, well, what harm has been done to the thing? It's a minimal payment. Well, the tribe doesn't feel that way about it because it's a reduction of the land base, and it's an important exercise of tribal authority to legislate. So I'm going to go through these two.
We've got two more minutes left.
Okay. I have 2 minutes left. Let me go. So these are the components of a pro-sovereignty right-of-way framework based on the 2016 ordinance. Includes a right-of-way ordinance that provides for a regulatory process, environmental reviews, et cetera, under tribal law, and a compensation that is not limited to market value, and provides for a stream of income, and of course for consent. This is more on the right-of-way ordinance, the sort of details of it. And then a trespass ordinance. This is important because a lot of rights-of-way have expired. So this provides an incentive for utilities to come into compliance. And it includes penalties that the tribe can prescribe rather than being limited to what might be available, the minimal penalties that might be available under state law. And then a property tax ordinance. The tribe has the authority to tax facilities on the reservation. These three components take full advantage of the regulatory framework established by the 2016 federal regulations, which are basically an encouragement for the tribes to take what had been federal control over the whole process and take it in-house. And then there's some strategic provisions here for those of you who are really interested on how to approach the utilities, because you can't be unreasonable about these things either. They have a point of view, and you have to factor in practical considerations, like who's being served for it and what your leverage is. I will leave it at that, since I guess my time has expired.
Great. Thank you for those very interesting comments. I think we're going to move on as soon as the screen is switched here to Amanda White Eagle.
Amanda, you can go ahead and start whenever you're ready.
All right. Would you like me to share my screen?
Yeah, if you've got a PowerPoint, you can go ahead and share your screen. You're all set up on our end.
All right. Well, I would like to say good afternoon, and thank you to Professor Fletcher and Dylan and Crystal. I would have much preferred being there. However, I got a cold, and it just seemed as though in the times of COVID, it's not best for me to be present, but I do appreciate this opportunity. So, looking at the Restatement of Law of American Indians, I determined to talk about hiding behind the skirt of tribal sovereignty. And I know that the powers of tribes should be settled. The Supreme Court has been very consistent with regards to sovereign immunity. However, I have a couple of points that I hope to make, and wanted to sort of preface this by indicating when I was in law school, and it sounds so old when people say that, but when I was in law school, it was between 2002 and 2005. And at that point in time, the state of federal Indian law, we had U.S. v. Law in 2004, along with Winter versus Penny Enterprises. And the state then was that federal Indian policy is, to say the least, schizophrenic, and that we don't know what the state of the law is until the Supreme Court tells us what it is, and then shortly thereafter it's better explained by history than by logic. So I had this as some of the underpinning when it came to the state of federal Indian law, and I think it caused me to be a little bit skeptical. With the Restatement of Law, I'll be specifically focusing on tribal authority through subchapter 2, section 25. Although I would note throughout the restatement, I believe that sovereign immunity is referenced in several chapters, several subchapters and sections. So getting started, I think when we think about sovereign immunity, we will also think about plenary power. And obviously heard about that a little bit in the last presentation, that there's a constitutional provision that says that the Congress shall have the power to regulate commerce with the Indian tribes, and then talks a bit about presidential power. But noting in Lone Wolf versus Hitchcock that the plenary authority over tribal relations of Indians has, from the beginning, been deemed a political one and not necessarily controlled by the judiciary. So with this discussion, I'm going to be talking about sovereign immunity in 3 separate sections. First, origins and scope, then federal abrogation, and then waivers. I think I'm going to spend some additional time on origins and scope, just because I think as a practitioner, as well as a judicial officer, I think the more we put emphasis on where sovereign immunity comes from, it'll have a greater impact on some of our decisions. So going here with tribal sovereign immunity absent express abrogation by federal statute, or an express tribal waiver that is properly authorized by the tribe, Indian tribes are immune from suit in other judicial processes through federal and state courts, except suits fought by the United States. So this is directly taken from the Restatement of the Law, and this is what I will be focusing on. So the restatement contains the origins of the sovereign immunity when it comes to tribes. In the mid-19th century, first case referenced is Parks versus Ross. And in that case, Samuel Parks was a Cherokee citizen that assisted with the Cherokee removal in 1838 and 1839. And he was not compensated for the use of wagons and horses. And ultimately, his executor, his son, sued on his behalf for the funds. And a jury found in favor of Ross and stated that he was the head of an independent nation and that could not be held personally liable. And the court affirmed, and this was the first reference to sovereign immunity, at least in the Supreme Court. And then again, in the mid-20th century, the United States was acting for Choctaw and Chickasaw nations, east of the coal lands to the Kansas and Texas Coal Company. And with the respondent, U.S. Fidelity and Guarantee Company acting as surety on a bond and guaranteeing the payment. Essentially, there was the leasee went into receivership, and there was a lot of procedural posture within the cases, but ultimately the district court found and the Court of Appeals affirmed that there was res judicata to the suit. But the Supreme Court reversed and held that the bankruptcy judgments were void and that res judicata was inapplicable. So this is another example on the Supreme Court level. But what I want to discuss a little bit, I'll reference two tribes, the Ho-Chunk Nation and the Mashpee Wampanoag tribe, because essentially both of those tribes trace their sovereignty to two independent, albeit intertwined sources, namely natural law and consent of the governed. So the Ho-Chunk Nation has the people or its general council, and through constitutional pronouncements articulated that the tribe maintained inherent sovereign powers. And this is by virtue of the tribe's independent self-governing since time immemorial, and that's contained within our preamble. Similarly, the Mashpee Wampanoag tribe also represents its sovereignty and origin as the people of the light within its preamble, and specifically references its sovereignty. But the constitutional text, you'll see, share a lot with, the Declaration of Independence or the documents of the Republic. And, each democracy, tribal and federal, have adopted, English juridical tradition. So, first I'm going to talk about the Constitution of the Ho-Chunk Nation. So Article 12 addresses sovereign immunity. Specifically, Section 1 talks about immunity, and then indicates that officials and employees acting within their scope of their duties shall be immune from suit. And then Section 2 deals with officials and employees acting outside the scope, noting that they are subject to suit and equity. Similarly, the Constitution of the Mashpee Wampanoag tribe has Article 6 that is completely their tribal council. Section 2 has the enumerated powers of the council, and then letter N indicates that to assert a defense to lawsuits against the tribe and to waive only by express written agreement the sovereign immunity of the tribe. But I also put a link to their website because they have very strong beliefs about sovereign immunity, and I think the pendulum has sort of swung. In some jurisdictions, like Ho-Chunk, there's limited waivers of sovereign immunity, and the nation has found this, I believe, in large part due to fairness. So there's a limited waiver of sovereign immunity with regards to employment. Potentially waivers with regards to contractual matters. However, at Mashpee, there are very few waivers. This is in the context of employment. They have a couple of seminal cases regarding sovereign immunity, which I'll talk about in a moment. But so now that we have these constitutional underpinnings, I'm going to talk a little bit about origins and scope when it comes to tradition and custom. So the two cases that I have up here are not sovereign immunity cases. So the question then comes, well, Amanda, why are you talking about two cases in your sovereign immunity discussion that don't involve sovereign immunity? It's because they have really strong references to tradition and custom. And the Daniel Brown versus Jane Webster case was a case in, I believe it was 2006, whereby Mr. Brown had spoke to the media negatively about the hiring practices of the Ho-Chunk Nation. And on the trial court level, the trial court found that First Amendment protections applied, and so that Mr. Brown should not have been terminated from employment. it went up to the Supreme Court, and what's notable is it was decided on a matter of tradition and custom. And so I put the quote in there, that this court is inclined to view the conduct of Mr. Brown as violative of the concept of logikete, which is a value that can be defined as respect. According to tradition, it is not the Hogen way for an individual who is a part of this community to independently take action without being respectful to the tribe and its leaders. So here we have the concept of respect or value and having that weigh against constitutional black letter of the law First Amendment protection. I actually had the opportunity to speak with the draftsman. So Dennis Funmaker Sr. was the author of the decision, as well as a member of our traditional court. And because I was so focused on the black letter of the law, I was like, Dennis, what's going on? Like, why did you write this decision the way in which you did? And we had a really long discussion about how tradition and custom should have an interplay with our constitutional text. And he did distinguish it later on and say that the trial court erred by not raising an issue before it, but there were some issues there. The former judge, Judge Boston, didn't pen the decision before he left. Judge Mesa, who's now the Supreme Court Chief Judge, actually authored the First Amendment case, but really just trying to show an example of tradition and custom. Another example is Ho-Chunk Nation versus Ross Olson. So this is a case that the court certified a question to the traditional court about contract law. And essentially, the traditional court stated that agreements between parties for the exchange of goods or services were recognized as binding. And it was wrong for one party to keep a benefit from the agreement and without providing the compensation. So this is the body of case law that's utilized for our contractual matters. So the tribe does have a UCC, but there was a subsequent case law, Corvettes on the Isthmus, which is also a Supreme Court case, that talked about the fact that the UCC was so truncated that it wasn't as useful for deciding contractual matters. So this is still what's utilized for contractual analysis, as well as the body of the contract, including a legislative resolution and the contract itself. So we have, multi-million-dollar contracts, such as any larger groups, Money Centers of America, relying upon the contractual matters. So again, kind of turning us back to sovereign immunity and its origins and scope. If you're working for a tribe as a practitioner, really making sure that the leaders or the draftsmen understand what implications sovereign immunity can have. So there is one case that I thought was really on point from the nation's perspective, Janet Funmaker versus Woodby Fairchild. And in this particular instance, the institution or this tribal employer indicated that they wanted to raise sovereign immunity and have the limited waiver, which was I believe at that point in time, was still $10,000 limited waiver for issues when it comes to employment. But the court in that instance looked at the different or what powers were being wielded and determined that it wasn't a judicial power. And so the legislature had delegated power to the executive to wield legislative authority. And so this wasn't a suit per se, but it was a grievance. And because the GRB wasn't a court, but rather a review board, sovereign immunity did not apply. And so since it didn't have any judicial authority, that wasn't the limit of the $10,000 maximum. I believe that was shortly thereafter fixed through legislation. But certainly that was an example of sovereign immunity and understanding the origins and scope. Similarly, just to talk about Mashpee Wampanoag for a moment, they have two cases that are, I guess, bound by stare decisis. One is Marie Cromwell, but that turns not just on sovereign immunity, but also on official immunity. But by and large, they're still working on their case law to try to determine what the bounds of sovereign immunity for their tribe, what those will be. So turning next to federal abrogation, the United States may abrogate tribal sovereign immunity by statute, but must expressly indicate its intention to do so. And I think the first case that really comes to mind, or the first law rather, is the Indian Gaming Regulatory Act. But the first case is Michigan versus Bay Mills Indian Community. And it's a really recent case. The Indian Gaming Regulatory Act provides that if certain requirements are met, including a compact between the state and the tribe, an Indian tribe can operate a casino on Indian lands. And in this case, it was under the Michigan Indian Land Claim Settlement Act. There were funds that were used to purchase land outside of the Bay Mills Indian Community, but in Vanderbilt, Michigan. And the state of Michigan sued for the closure of the casino and indicated that it violated state gaming laws as well as provisions of the state tribal compact. But the U.S. Court of Appeals for the Sixth Circuit vacated the injunction and held that the district court lacked jurisdiction because it was barred by sovereign immunity. So I do think that that's the seminal case right now with regards to federal abrogation. And it was very clear in this decision that the court would not intercede, but would rather defer to Congress. And it has to be unequivocal and for that purpose. And went back to the plenary authority and that doctrine to say that it's up to Congress. And I believe shortly thereafter there was an effort to, and I think it's an ongoing effort, right, to limit sovereign immunity for tribes. And this morning I went through all the open cases in all of the circuits regarding what they call, like, I think they use terms like rent a tribe for like cash systems, or check cashing systems. And there are about 14 open cases that I saw just from a cursory glance attacking sovereign immunity because of those entities where you're making 700% back for a check cashing. So turning a little bit to waiver.
Amanda, can I interrupt for just quickly, just a couple of minutes to wrap up, if that's okay?
Yep, that's great. So waivers have to be clear and express, and tribal law governs the waiver. So if there's a waiver, you have to ensure that the laws that are on the books are apt. So I do have a circuit split as to whether or not there's unauthorized acts of tribal officials to waive sovereign immunity. I have those cases there. But since I only have a couple of minutes left, I wanted to talk about waivers. And I did, I think in previous years, have gone to the TICA conference, the Tribal In-House Council conference, and talked about, like, hey, can you guys share your waivers? And I'm proud to say that I think Ho-Chunk has the best one. I think attorneys Hewling and Green Deer Rays and Scherzel have worked on a document for boilerplate waivers of sovereign immunity that again, going back to that Corvettes on the Isthmus case, in that particular case, the DOJ had not looked at what the waiver would have looked like. But ultimately, the DOJ now, at least at the Hogen Nation, has in place boilerplate language. And it needs to ensure that the language is strong. And if there is a limited waiver, and I do think that limited waivers are necessary as we're attempting to do business with outside entities, how that would look, and in making sure that it's not assignable to any type of successor folks. The nation does have different waivers of sovereign immunity when it comes to construction versus contractual. So thank you very much for your time today.
Thank you very much, Amanda. Before moving on, I've forgotten the secret words for the CLE credits, so I need to catch up. So the first secret word is rules. Rules is the first secret word. And before moving on to Brian, I will tell you the second secret word, which is code. Code. Brian, 20 minutes, and then we'll do
Andrew's next.
Oh, I'm sorry, not Brian. I'm looking at the secret word side of here. Andrew, I'm sorry. Andrew is
Andrew, we can't hear you.
Okay, can folks hear me? Okay. Yeah, I've been having problems with the mic on my Zoom setup, so my apologies about that. But good afternoon, everyone. My name is Andrew Adams, and as was stated in the introductions, I'm an attorney at Hogen Adams in St. Paul, Minnesota. I am a proud product of the Big Ten. So I've got an undergrad.
I don't know if you can hear us.
Yes.
Can you just start? We had like this crazy audio sound on our end, but we've managed to fix it. So if you can just pick up from the beginning of your presentation, we'll get going.
Okay.
All right. Thank you.
Okay.
Sorry about that. Thank you.
Yeah. So good afternoon, everyone. My name is Andrew Adams. I'm a citizen of the Muskogee Nation of Oklahoma. Detroit, Michigan is my hometown, and I am a proud product of the Big Ten. I graduated from the University of Michigan with a bachelor's and a master's degree, and am a proud graduate of the University of Wisconsin Law School. And I am a partner at Hogen Adams in St. Paul, Minnesota. And we are a small boutique law firm that represents tribes all across the country. And I tell people this story, and sometimes I get a laugh out of them, but like every morning I wake up, feeling like Luke Skywalker because I get to represent the good guys. And that's no disrespect to anybody that may work for like a state government or the federal government, but they're definitely, I don't think they could say that they're feeling like Luke Skywalker in the morning. So, but maybe I'm wrong. I don't know. But so what I'm going to talk about this afternoon is the importance of treaties and the power that comes from treaties, even to this day. If any of you had asked me when I was in law school, if I thought that 15 years later in my daily practice as a Indian law practitioner, that treaties were going to be important, I probably would have had a different answer, because at the time I personally didn't believe that they were going to be that significant. But right now, and especially for the last 10 years, treaties have been kind of at the forefront of my practice. And so to tie it back to the restatement, and I'm not going to read this to you, but Indian country is defined in the U.S. Code. And the piece that I'm going to focus on today are reservation lands. There are other quote unquote like definitions of Indian country, and that would be dependent Indian communities, Indian allotments, and land that's held in trust by the United States. But I am going to focus on reservations and treaties and why they are important. So if you look at this map, I mean, this map from like 30,000 feet like shows different tribal areas, if you want to call it that, from like a land standpoint. And these areas that are in like bigger kind of shaded colors represent, in kind of an abstract way, they represent treaty areas. And then these defined bounded boxes that you see are like specific reservations that were reserved lands from treaties. And so back in the mid 1800s, George Minniepenny, who was the Commissioner of Indian Affairs, he was the primary architect of the early reservation policy that essentially was put in place so that tribes could create permanent homelands. And I think that term, permanent homelands, is critically important for tribes today and for Indian law practitioners that are dealing in treaty litigation. But most importantly, permanent homelands are extremely important for tribal governments and their elected officials, because without land, without a territory by which the government has the ability to exercise authority, there are other tenets within federal Indian law that just they wouldn't come into play for that tribal government. And so in the treaty with the Chippewa from 1854, it lays out specifically where these reservations are going to be for the different Lake Superior bands. And this, again, is another map that shows the 1836 treaty area in what is now called Michigan. You've got the 36 area in Wisconsin, or what's now called Wisconsin, the 42 area in both Michigan and in Wisconsin, and then the 54 area. And when I say 54 area, I mean a cession area. This, again, is another map. And the reason why I'm showing these maps is because these areas are areas that were ceded by tribes in these years through treaties. But then this, and I realize that this is kind of a bad map in terms of like the coding. It's an old map, but this kind of shows you what was left in 54. Again, in 37 and 42, these are areas that where cessions occurred, so that these, at the time, territories and now states, so these areas could essentially come into the Union. So it didn't really connect the dots in my mind until a few years ago when I got my first taste of like treaty litigation, that one of the reasons why these treaties were needed in the Great Lakes region, at least, was essentially to paved the way for these territories to then become states. So you have the 36 Treaty with the Ottawa that signed in 1836 in Michigan. And then it's no coincidence that Michigan becomes the 26th state the following year. And again, in what's now called Wisconsin, you have the 37 and the 42 treaties. And then again, it's not a coincidence that then Wisconsin is accepted into the Union as the 30th state in 48. And so treaties are extremely important. You know, in Lozano v. Montoya Alvarez, a treaty is in its nature a contract between nations rather than an ordinary legislative act. You've got in Mille Lacs Band, as the Indian themselves would have understood them. So treaties have to be interpreted, you know, from the vantage of the Indian ancestors, the ancestors of Indians that exist today. I mean, at the time, some of these Indian folks that were negotiating with the United States at the time, they may have been relying upon interpreters that were hired by the United States. There may only be a treaty journal that is only in English and is not in the language that was spoken by the indigenous folks that were negotiating the treaty. And so this canon that came out of Mille Lacs is extremely important in terms of how treaties are interpreted today. As all of you in law school hopefully have learned in constitutional law, you know, treaties are the supreme law of the land. There's no differentiation between say a treaty between the United States and France, right? Or one with Japan. I mean, the ones that were signed between the indigenous tribes that were here when treaty making was still allowed with tribes are on an equal footing with those other international treaties. Again, in Mille Lacs, the court said that Congress can unilaterally abrogate Indian treaties, but if they do so, that abrogation has to be clearly, it's got to be clearly expressed. It cannot be insinuated. It cannot be implied. Only Congress can alter the terms of an Indian treaty by diminishing a reservation. So again, there can't be some, it can't be implied. It's got to be there. In Nebraska v. Parker, where they were quoting Bartlett, only Congress can divest a reservation of its land and diminish its boundaries, and its intent to do so must be clear. It has to be expressly clear. It can't be insinuated by some letter that was sent by some, you know, officer in the United States Bureau of Land Management to some bureaucrat like in the Department of the Interior, that where they, you know, don't refer to a tribe's permanent homelands as its reservation, and then that be the basis by which someone says, well, that reservation doesn't exist anymore because these two federal officials were discussing their land base but didn't call it a reservation. Again, in Parker, only Congress has the power to diminish a reservation. So what I'm leading up to is like the McGirt case, the McGirt case that I, as a Muskogee citizen, just, I couldn't believe that the United States Supreme Court had gotten it so right. And in terms of like planets aligning, I was actually traveling with my children back to Oklahoma to attend my ceremonial grounds. Our green corn was happening that same week that the court handed down the decision. And so the crazy thing is that the day that we were traveling is when the court handed down its decision, and my my middle kid, Andrew Adams IV, turned to me and he said, well, guess what, Pops? You're going to wake up tomorrow morning on the Muskogee Reservation. And to hear my 15-year-old tell me that, it's kind of hard to put into words as a Muskogee citizen, just how important this has always been to our nation. And to have the fellow sovereign that signed that treaty with us, like, finally acknowledge the power of that agreement in their highest court, it's kind of difficult to put into words like how important that was. But so pre-McGirt, when it came to diminishment and disestablishment, the court laid it out in Solemn v. Bartlett, which was decided in '84, and it prefaced its analysis with this: that the first and governing principle is that only Congress can divest a reservation of its land and diminish its boundaries. Once a block of land is set aside for an Indian reservation, and no matter what happens to the title of individual plots within that area, the entire block retains its reservation status until Congress explicitly indicates otherwise. So the test is, you look at the language of the statute. This is solemn. You look at the legislative history of the statute, and then you look at events after the passage of the act, i.e., or e.g., how did Congress, the BIA, and local jurisdictions treat the area? So number 3 is where you've got the official in the Bureau of Land Management writing a letter to someone in Interior and not mentioning the reservation. And then McGirt happens, right? And in McGirt, I'm not going to bore you with all the details, but it involved a post-conviction challenge to Oklahoma convictions for offenses that were committed by a tribal member within what he claimed were the Creek Nation's reservation boundaries. I'll use Creek Nation because that's how the court used it, but I identify as a Muskogee person, not as a Creek person. Under the Major Crimes Act, any Indian who commits an enumerated crime within Indian country is subject to the exclusive jurisdiction of the United States, not the state by which they reside in or where the offense occurred in. The Creek reservation was established by treaties in the past, of course. Oklahoma argued that by authorizing allotment, which led to eventual sale of Creek lands to non-Indians in many cases, Congress intended to diminish the Creek reservation. Again, that third prong of solemn. That Congress believed, quote, the reservation system would cease, end quote, due to the allotment was not enough. The court said to equate allotment with disestablishment would confuse the first step of a march with its arrival at its destination, end quote. Oklahoma also relied on several other statutes, namely that Congress abolished the Creek tribal courts in 1898. Congress required tribal laws to be approved by the president, and the allotment agreement said that Creek tribal government wouldn't exist after 1906, subject to further legislation. The hilarious thing about the state of Oklahoma's reliance upon that first one, that the Creek tribal courts were abolished in 1898. The one interesting tidbit that I want to provide to you guys, and what's kind of cool about history, is that my great-great-grandfather, Thomas J. Adams, actually served as the Chief Justice of the Muskogee Nation Supreme Court back, I think his term was like 1890 to 1894. And I have also served as Chief Justice of our Supreme Court also. And so, I mean, just from a historical standpoint, I think it would have been fascinating for the state to really think hard about Congress abolishing the Creek tribal courts in 1898 as a basis by which to say that shows the intent, because I mean, we've had a court, and yes, you know, Congress may have abolished it, but we still had a court, if that makes sense. The Five Civilized Tribes Act of 1906 did not dissolve the Creek government. Rather, Congress expressly recognized that the Creek Nation's existence and present tribal government. In the IRA in 34, it authorized my nation to adopt a constitution, which we later did, but that didn't happen until like the 1970s. Quote, in all this history, there simply arrived no moment when any act of Congress dissolved the Creek tribe or disestablished its reservation. In the end, Congress moved in the opposite direction, end quote. The court summarized the very limited way it had used historical practices and said, to clear up any confusion, we restate the point. There is no need to consult extra textual sources when the meaning of a statute's terms is clear, nor may extra textual sources overcome those terms. The only role such materials can properly play is to help, quote, clear up, not create ambiguity about a statute's original meaning. Oklahoma tried to rely on what had been the third prong of the court's diminishment analysis, jurisdictional history and demographics. The court called this mistaken. When interpreting Congress's work in this arena, no less than in any other, our charge is usually to ascertain and follow the original meaning of the law before us. That is the only step proper for a court of law. Oklahoma asked the court to focus on the potential that thousands of convictions would be upended and 1.8 million people could find themselves living in an Indian country. I mean, like total doom and gloom, right? That, oh my goodness, like what's gonna happen if I wake up and I'm on an Indian reservation or my house is here, or the Starbucks that I love to frequent on Peoria at 31st is actually on an Indian reservation. The court refused, saying that the magnitude of a legal consequence is no reason to perpetrate it. McGirt did not restate the three-part test that was created in Solemn. The court will rely almost exclusively on the statutory text. The court may look to contemporaneous legislative history, but only if the statutory language is vague. There is no need to consult extra textual sources when the statute is clear. This is what the court handed down in McGirt. So that brings us to the collateral impact of McGirt on cases that have come afterwards or that were in the courts at the same time. And you've got the Oneida Nation versus Village of Hobart case here in Wisconsin. The nation had the burden of proof to show that the 38 Treaty created the Oneida Reservation as a block rather than as a collection of allotments. The village had the burden to show that the Oneida Reservation, if established, had been diminished or disestablished. The village had the burden of proving that if the reservation existed, there were exceptional circumstances that would justify the village exercising jurisdiction over the nation on reservation land. The 38 Treaty language agreed to reserve, quote, to the said Indians to be held as other Indian lands are held, a tract of land containing 100 acres for each individual, and the lines of which shall be run to include all their settlements and improvements in the vicinity of Green Bay, end quote. And then it relied on some math, and then in a map, a survey was created for the reservation, which is key in terms of the historical context. I'm kind of a visual learner, so this is kind of like a representation of the Oneida Reservation from a few years ago, I believe, actually in 2019. At the district court, the court held, I conclude that fee lands within the original boundaries of the Oneida Reservation that were sold to non-Indians unless reacquired and placed in trust by the federal government, are no longer a part of that reservation. The loss of that land has resulted in the diminishment of the reservation from its original boundaries, end quote. When all of the Indian law practitioners in Wisconsin read this decision, and I think it was Judge Griesbach, I think that's his name, we all thought that like he had fallen out of a tree and hit his head, because there's nothing in the Dawes Act that says that when land is allotted, that reservation boundaries then are impacted because of those allotments. So he took a huge stretch to come to this conclusion, and it wasn't founded in federal case law, especially federal case law that's been handed down by the Supreme Court. So luckily, the Seventh Circuit had the benefits of McGirt by which to hand down their decision correcting the Eastern District of Wisconsin. And they held that the village could not show diminishment, and found that the village's legal theory was flawed because it relied on incremental diminishment by allotment, leaving a checkerboard, and the Supreme Court already rejected that theory several times and in several other cases. Relied on Congress's general expectation that Indian reservations would fade away after allotment, but that's not contemporaneous evidence of congressional intent to diminish at all. And relied on General Allotment Act and Appropriations Act that were generally applicable and showed no intent by Congress to diminish the Oneida Reservation. Again, just to be as clear as I can, when a reservation is going to be diminished, Congress has to express that intent expressly. It has to be clear. It can't be insinuated. It can't be implied. It cannot be wished. And with that, if anyone has any questions, feel free to reach out to me. I love to talk about this stuff, and I really appreciate the invitation to visit with you all today. And I wish it could have been in person, but between my kids and work, I needed to stay in St. Paul. So thank you again.
So we're almost out of time, guys. Let me just mention in bulk here my two last secret words for the CLE people. So we have order as number 3, order, and our fourth one is act. Act is the fourth one. So we have time for, I think, probably one quick question if we're going to break on time. Is that right?
So I think just in terms of time, I think we'll just drop it here,
Okay.
just so we can kind of get out a little early and get our last speaker introduced. Thank you so much, Brian, Amanda, and Andrew, for your presentations. And thank you for